Three, two, one, start. Section 374 Appeal against conviction. An appeal is a statutory right and an offender who has been convicted is entitled to avail the right of appeal. Such right is also a fundamental right, as conviction affects the liberty of a person. This right of appeal can neither be interfered with or inspired, nor can be subjected to any condition. Although right of appeal, being a vested right, cannot be taken away, right of the court cannot be taken away to suspend the sentence. Such a provision would be ultra vires. Full stop. Section 378 Appeal against acquittal. Broad principle for resorting to such power is that the presumption of innocence is strengthened if an accused is acquitted by the trial court, and that a reversal of the trial court's judgment should be made in cases where the view taken was not possible on the evidence, or perverse with the broad understanding that if two views were possible, the one taken by the trial court in favor of the accused be retained. Full stop. Section 389 Suspension of execution of sentence pending appeal and release on bail. There is distinction between bail and suspension of sentence. One of the essential ingredients of Section 389 is the requirement for the appellate court to record reasons in writing or ordering suspension of execution of the sentence, or order appealed. Requirement of according reason indicates that there has to be careful consideration of the relevant aspects, and the order directing suspension of sentence and grant of bail should not be passed as a matter of routine. Appellate court is duty bound to objectively assess the matter and to record reasons for the conclusion that the case warrants suspension of execution of sentence and grant of bail. Mere fact that during trial accused persons were granted bail and there was no allegation of misuse of liberty does not per se warrant suspension of execution of sentence and grant of bail. Effect of bail granted during trial loses significance when, on completion of trial, accused persons have been found guilty. What really is necessary to be considered is whether reasons existed to suspend the execution of sentence and grant of bail. Full stop. Section 438 Bail allegation of committing organized crime under Section 24 of Maharashtra Control of Organized Crime Act 1999. Maximum punishment provided under Section 24 of MCOCA is 3 years. Already been in judicial custody for over 2 years. Fit case for grant of bail. Full stop. Sections 438 and 439 Bail Guidelines for Granting Bail. The detailed examination of the evidence and elaborate documentation of the merits of the case is to be avoided by the court while passing orders on bail applications, yet a court dealing with the bail application should be satisfied as to whether there is prima facie case, comma, but exhaustive exploration of the merits of the case is not necessary. Court dealing with the bail application is required to exercise its discretion in a judicious manner and not as a matter of course. There is a need to indicate in the order, comma, reason for prima facie concluding why bail was being granted, particularly where an accused was charged of having committed a serious offense. It is necessary for the courts dealing with bail application to consider. Full stop.